Madam Chief Justice, Madam Deputy Chief Justice, my lords, my ladies, I am to address myself to the sixth issue of the court, whether the IBC carried on the verification, tallying, and declaration of results in accordance with Article 138(3)(c) and Article 138(10) of the Constitution. The thrust of my presentation is that the nature of management of elections in Kenya from even before the new constitution have been that decisions as to who has won the presidential election are collegiate. And that the collegiate nature of the decision as to who is the winner of a presidential election goes down to the description of what is a free and fair election under Article 81. And in Article 81E, the Constitution describes a free and fair election as an election, E3, conducted by an independent body, 4, transparent, and 5, administered in an impartial, neutral, efficient, accurate, and accountable manner. And it is my submission that this goes not to just what the Constitution says, but what Kenyans have practiced and what they have come to expect whenever bodies are making decisions. Possibly, more than any other body, the judiciary has been able to show Kenya the nature of collegiate decision making. We have had live court sessions from the High Court to the Court of Appeal to the Supreme Court. Kenyans have seen often the presiding judge, in this case even the Chief Justice, consult even sometimes openly with other judges before the court arrives at a decision on even very small things. And we have even had situations when a decision becomes grave. We have seen judges retire to go so that they come back with a collegiate decision. So that is what Kenyans have come to expect, and that is also what Kenyans expect even from the Independent Electoral and Boundaries Commission. First, the nature, our commissions are made up of at least 3 members and at most 9. And if you look at the qualifications of all these members, they are all, whether it is the chairman or the members, largely have the same qualifications. They are all identified and recommended for appointment among the same criteria. They are all approved by the National Assembly. They are all appointed by the President. So there is no basis on which the chair of any commission can treat as subordinate members of that commission or treat them as if they have lesser qualifications or lesser competencies than him. They all enjoy the same security of tenure. They all enjoy the same security in their remuneration. And so they are all expected to execute very substantive mandates. My Lord, this question as to the mandates of commissioners came up in the case of Michael Kamau versus the Ethics and Anti-Corruption Commission, which is in our list of authorities, came up in the High Court and came up in the Court of Appeal. And the court, both courts were very categorical as to the fact that the constitutional mandate of a commission is borne by the commissioners. And in that case, where a commission had attempted to reach a decision without commissioners, the court annulled that decision and said that that decision had to be made by commissioners. And in respect of the powers of a chairperson, again, the minor KI case, all the way from the High Court to the Court of Appeal and to this court, have made it clear that the chairperson is not the commission and that he has to act with the rest of the commission for him to deliver a proper constitutional decision. So that collegiate nature of the decision making in a commission is captured very well in Article 138 3C and in Section 39 1C of the Elections Act, which make it very clear that it is for the commission to tally and verify the results. And in Article 138.10 is only where the chairman is asked to declare the result of that decision. And our submission is that the requirement to declare does not give the chairman any power to tally, to verify, or even to reach a decision as to what he is going to declare. That part of the Constitution was first captured in Section 41 of our previous Constitution, in subsection 11, which had a proviso that provided any decision of the commission shall require the concurrence of a majority of its members. And that is why I say the collegiate nature of decision making at the Electoral Commission even precedes our new constitution. And at that time, there was an attempt, which I will submit is an attempt that has also been made this time by the chair of the Electoral Commission, to take away that collegiate nature of decision making at the commission. And if you read the Kriegler report, which is also next to a list, it talks of an attempt at that time, or actually an actual creation at that time, of an office that was called the Supervisor of Elections. And the Supervisor of Elections was an executive office that was used to undermine the independence of the Electoral Commission of Kenya. And as we moved to the first multi-party elections, one of the first insistence that Kenyans had was that the Supervisor of Elections must be removed and that decision-making regarding elections must be taken back to the ECK. But that was not even enough, because Kenya still felt then that Section 41 was still not clear enough. And in Act number 6 of 1992, which preceded the first multi-party elections, Kenyans insisted that the mandate of the commission be made clearer, and we now promulgated Section 42A into the old constitution. And Section 42A made it very clear that the Electoral Commission shall be responsible for directing, supervising presidential, national, and local government elections. So by the time we were coming to the new constitution, we had already taken a position that decisions regarding presidential elections have to be collegiate. When the new constitution itself was being promulgated, there were several options that the framers of the constitution could have. They could go back to making this the decision of an independent office, as Mr. Afula Chebukati has attempted to act, but instead they created, for the first time, what they called independent offices, created the DPP, the Auditor General, and Controller of Budget as independent offices, but found it wise to retain the collegiate nature of decision making as an act of the commission. The question then we asked is, why is it necessary for there to be a collegiate nature in the decision making regarding presidential elections? I said, one is because it gives integrity to the decision. And the more important a decision is, the more it may require more people to make it. And we see that also in our court system, where decisions are made in the High Court by one judge have to be made by 3, in the Court of Appeal and have to be made by 5 at the Supreme Court. And this is even being seen in sports today, that in very important matches, they have even moved away from leaving critical decisions to one referee. And we have now gone to even video-assisted refereeing so that more people can weigh in on a decision that is that important. The second thing is that the collegiate nature secures the independence of the commission itself, so that you don't have one person who can be in a position where they cannot resist maybe pressure. And therefore, so long as we know that there are 7 people making this decision, we are more confident about its independence. But thirdly, my lady, my lords, there is also the question of the legitimacy of the decision. And this comes from what this court said in 2017. And in paragraph 371, in the case of Raila Odinga versus IEBC, the court says that elections are the surest way through which the people express their sovereignty. Our constitution is founded upon the immutable principle in the sovereign will of the people. It says that, in fact, it is the people and they alone in whom all power resides, be it moral, political, or legal. And so they exercise such power either directly or through their representatives, whom they democratically elect in free, fair, transparent, and credible elections. Therefore, whether it be about numbers, whether it be about laws, whether it be about processes, an election at the end of the day must be a true reflection of the will of the people. And I view legitimacy in 2 ways. That first, it is very important for Kenyans to believe that the decision has been arrived at is legitimate. And the reason for that is because it is in one person. They have been asked, or they have asked to delegate their sovereign authority. So they believe that a decision has been reached that is legitimate is very important. And you see that in Article 131, that political legitimacy of that decision is covered in Article 131 of our Constitution. Because Article 131 gives our president 4 powers. He makes him the head of state and government in paragraph A. In paragraph C, it makes him the commander-in-chief. In paragraph D, it makes him the chairperson of the National Security Council. And then in paragraph E, it makes him the symbol of national unity. So of all the 4 things that our president must do, the A is the political legitimacy. And if decisions are arrived at as to who has won an election, and they do not carry with them the legitimacy that is required, then you have somebody who cannot exercise the duties, execute the duties under 131E as being the symbol of national unity. But there's a second reason. And the second reason is that also the person to whom you now declare as the president must himself believe in the legitimacy of the decision that has been made. And political scientists say that this political legitimacy is necessary because it finally determines how that person themselves will hand over that power. And political scientists say that power that is unjustly acquired will never be justly given. So if you want to have a legitimate transfer of power in a country into the future, you must ensure that that power is also known not just to the public, but to the person who acquires it as legitimately obtained. The question then comes to where we find ourselves today, where we have the chairman and a minority group saying they carry the day in this decision, and we have 4 commissioners. And the question this court has to ask is who would it believe? And it's our position that Mr. Wafula Chebukati has disrespected the Constitution, has been unable to secure the legitimate result of an election that was conducted. And in terms of deciding who to believe, my lord, first and foremost, Mr. Ofula Chebukati has not had a complaint to make as to how these four commissioners worked ever since they entered the commission in September 2021. On the other hand, there are lists of complaints as to how he himself has conducted this election that start way back from 2017, that he bungled up the 2017 elections. We've captured in a petition that he has had four other commissioners resign on him previously. There's unilaterally printed ballots. He's unilaterally made decisions about use of registers. And in our both affidavits and petition, we have made a list of all the misconduct that he himself has executed. And the result of all that, you come to the conclusion that what the chairman has attempted to do is to install himself as a new age supervisor of election, totally emasculate the role of all other commissioners, and you now have a decision that is his, supported by a minority of the commission. And our argument is that that declaration is not a constitutional declaration. That declaration is unable to found the declaration that was supposed to be made under Article 131.8. And one of the most glaring things that comes also from that conduct is the issue of the 27 constituencies. And the ninth respondent knows the importance of that, because in paragraph 6 of his affidavit, he purports that those results were read. He purports that, in fact, that the disaffected commissioners announced those results. But the affidavit of Professor Goulier and the response of Chebukati themselves clearly say that those 27 constituencies were not verified and announced. And the reason for that, according to the four commissioners, is because he emasculated the role of the other commissioners and they never sat down as a commission. I will finish my presentation as to the unconstitutionality of that declaration with two examples. We have had previously a situation such as this in the Truth, Justice and Reconciliation Commission. I will ask the court to take judicial notice of what had transpired as the commissioners fought with their chairman regarding what was the report of the commission. And it was very clear that the report of the commission had to be what was decided by the commissioners. But I will also leave this presentation with something closer home. In the past couple of years, there has been a dispute between the executive arm of this country and the judiciary regarding who makes the decision as who becomes a judge. And it has been the position of the national executive that the power to appoint comes with it with some form of power to decide. And this judiciary has been very clear all the way from the High Court to this court that the power to appoint in no way includes a power to decide on who becomes a judge. I say that for the same reason, the power given to the chairman of IEBC to declare the result of an election in no way gives him any power to decide what that result will be. And if we cannot be shown how the commission as a commission reached a decision or reached the decision that was pronounced by its chair on the 15th of August, then I implore this court to use the same reasoning and tell the chairman in the same voice that it has told the national executive that your power to declare does not give you any power to decide on what you declare. That is all, my lord.